I'm going to mute you. All right, we're gonna get started here in about 30 seconds. Excited to talk to you guys about small businesses and business formation issues in 2021. All right, guys. Well, welcome to today's episode of The Debt Life with me, Chad Van Horn. Today's topic will be all about business formation and business issues. I'm happy to have a guest today who is a good friend of mine, fantastic attorney, Mr. Paul Kogan. Paul, how you doing today? Let's bring you onto the screen if I know how to do that. There he is.
I'm doing great, thank you.
All right, Paul. So give us a little background about yourself, if you would.
Sure. I've been practicing for about 11 years, almost 12 actually, coming up. I've known Chad for now almost 16 years. We've been really good friends. A little about my business. I practice corporate law. I do both transactional work and litigation. Most of my transactional work, I deal with small companies that are just starting, to companies that are multi-million, some into the hundreds of millions of dollars. So I'm able to help anyone, and ready to talk.
Fantastic. Yes. Well, let's jump right into it. I get many people that come into my office, and you get a lot of these referrals, and they say, I want to start a business. I have this brilliant idea. We're going to make $1 million with this business idea. How do we get started? So what are some of the first steps when somebody comes in with their $1 million or $1 billion idea?
Sometimes it's just talking to them. The first step is to find out exactly where they're trying to go. Find out what the short-term plan over the next few months, over the next year, over the next 5 years, over the next 10 years. If they are going to keep it a small mom and pop shop, there's one way of doing it. If they're going to be a multi-million-dollar company that they're going to try to sell to some venture company, we got to approach it a little differently. So the first step is always to kind of get an idea of where the company's headed and what their goals are ultimately.
Yep. And I always tell, especially small business owners, initially keep it cheap. Don't spend a ton of money on admin fees. You make $1 first. Prove your business model before you start getting that $10,000 shareholders agreement whenever you're the only owner of it. So if you are, and many of my clients, if you are starting a true small business where you're the only owner, what are some of the basic things that you would need?
Well, just to start, I mean, it's always simplified. I get calls all the time. Well, I need to hire an attorney to open up a company. The simple thing, and Florida makes it simple. A lot of states make it simple, not just Florida, is to incorporate, whether it's an LLC or a corporation. It's pretty straightforward. Go online to sunbiz.org. They click on a couple of buttons, pay them $75 to $125, and your business is open. That's the simple way. It's always recommended that you talk to an attorney just to kind of make sure that you're doing the right thing. But Florida does simplify opening your own business, and sometimes just that quick conversation of 10 to 15 minutes helps people understand that, hey, starting a business isn't too complicated. It's pretty straightforward.
Yep, absolutely. Sunbiz.org has definitely been our friend. For the people that haven't used it in the past or have used it in the past, if you're setting up a business now because of COVID, I understand that there are some delays in getting your information. It used to be within a day or two. Now I'm hearing it's a couple weeks. Is that what you're seeing as well?
Yeah, I've seen delays of 2 to 3 weeks, even electronically filed documents. I've had one where it was over a month. Wow. It depends on what's being done. It's a little faster now, but a couple of months ago, it was taking a while just because they probably didn't have too many people working there as well.
That makes sense. All right, let's jump into some do's and don'ts that you've seen. So we start the business, money's coming in. What are some do's and don'ts whenever we actually have our business? It's already formed and it's operating, and we're bringing in some money.
Sure. I'm actually going to take one step back to formation, and it's the type of company you need to start. A lot of people hear LLCs and they're super excited. Hey, I get calls all the time. I need to start an LLC. In Florida, that's usually not the best suggestion if you're the only owner of the company. There's some case law out there that basically says that an LLC is the same as the individual. So be very, very careful opening up an LLC if you're just a single member. In those cases, in Florida, I definitely recommend doing a corporation, whether it's an Inc. or a Corp. So after formation, once you have that figured out, the main thing is to make sure that you're obviously operating at a general income as opposed to incurring a ton of debt. Your business from a day-to-day standpoint knows what they're doing as opposed to just kind of doing everything willy-nilly. But I know you've seen a ton of people come in saying, hey, I started a business, and then a few months later they got a ton of debt and they can't do anything.
And what I see a lot of, especially for new businesses, are landlords that really will take advantage of a new business owner. So be careful, especially if you're going into an empty shell or something that you're going to have to modify. The landlord may give you tenant improvements or TI, as they call it. For almost every new business that I see, it's not enough. They end up having to spend a lot more money. They get loans, they get credit cards, and you're putting yourself in a deeper hole. And you can't really start operating your business until that space is built out, especially if you're in some sort of service where you need service business where you need the space. You need people to come into the space, whether it be a barber shop or a restaurant or something like that. So just be very careful when you execute any legal document that you have an attorney or somebody review it so that you understand the ramifications of it. And remember, it is a true negotiation. There's a lot of space available right now. Unfortunately, due to COVID, a lot of businesses have gone under. So these landlords need new businesses to come in there. So don't just go in and see the asking price and say, okay, where do I sign? Make sure you're negotiating and you understand that if there's a personal guarantee, if there's a lien on assets, or if there's anything like that. Have you seen anything with regards to different tenants or issues tenants are running into?
With tenants, obviously right now is one of those interesting times where a lot of them are in default. So discuss or having negotiations with landlords is always a priority right now. I've represented both landlords and tenants, and to my landlords, I always tell them, hey, it's better to negotiate something and know you're going to get something right now, as opposed to having to fight something in court that's going to take a month or two where you're going to definitely lose money. So, and the same conversations with a tenant where, hey, negotiate, make sure that what you're doing is proper. Along the lines of just the leases, I think when you're starting a business, you're going to be inundated with a ton of contracts. And a lot of people will think, hey, I'll read it, I'll just sign it, and everything will be okay. And never consult with somebody. Unfortunately, I get a lot of cases or a lot of people come in afterwards where there are issues with those contracts later on. And there's not much we can do because they didn't consult or in the beginning. And just in general, it's a lot cheaper to consult with an attorney and have them review a contract in the beginning than have to deal with the issues later on. I mean, it's something that would have cost a few $100s in the beginning and is now adding up to thousands and thousands of dollars.
For sure, and you know, moving on to the next topic, you know, when a breach of an agreement happens, whether it be a landlord, a loan payment, or something with a vendor, what do you recommend? You know, prior to litigation, what do you recommend if I know that I'm not going to have the money to come in to pay one of my vendors, and I know I'm going to breach my agreement because I just don't have the capital to do it. Do you recommend that the business owner just runs and hides? What do you recommend doing at that point?
So running and hiding is never recommended. It's just going to make things worse and worse. It's going to end up ballooning into something that might have cost you $1,000 at the beginning, ends up costing you $10,000-$15,000 because now the vendor is suing you, and the contract contains a attorney's fee provision that the attorney for this vendor is just racking up. It's always best to contact the vendor, try to work something out. As I was saying, I prefer to negotiate something where both parties, for the most part, are unhappy, but at least solved. There's no reason to waste time and the stress where you're just running away from it.
For sure, and I think we're both from the school of thought that, generally speaking, when you get into litigation, the only winners are the lawyers, because they end up getting paid, and both sides are usually expending capital that would be better served going into their businesses instead of fighting each other. So I agree that if you are falling behind with your vendors, reach out to them immediately, whether it be the landlord, whether it be a vendor or somebody that you have a contract with. Reach out to them and try to work something out before it turns to litigation. We have a couple questions that I'm going to put up on the screen. Kimberly, thanks for the info, spreading the word. I'll touch base with you once I settle into my new job. Awesome. Christina, let's put that on the screen. What is the best way to fund a new business if I don't have much money in savings? Do you have an answer for that, Paul?
I think that's usually the hardest part, funding, right? And it depends on what your business is. Certain businesses don't necessarily need a ton of funding in the beginning. So you're able to possibly just work with a computer and that's it. Other businesses need a ton of funding. It just depends on the type of business. Funding is always the hardest part. It's tough to figure out where to get the money. It's just a matter of the type of business.
Yeah, and we talk about things like bootstrapping, utilizing your credit, utilizing family and friends for money. Obviously, we're in a difficult time where a lot of people are struggling for money. So, if you have a good idea, if you're very passionate about it, I normally don't recommend people going into debt. But if this is the way that you're going to generate revenue for you and your family, take that chance. And the Bankruptcy Code, which I talk about quite often, one of the reasons that the Bankruptcy Code was put together was for entrepreneurship. It was to encourage people to take risks that you otherwise wouldn't take if going bankrupt would put you into jail if we didn't have the bankruptcy system. So,
the hardest part is always just starting. Just start.
Of course.
Sometimes just a simple incorporation to get you or starting the business is all you need, and then once you get that little push, that's all it takes. And if you believe in your business, the funding will come. That'll definitely happen.
All right, now here's a question that's right off of that. So some people will take a silent owner in to get the capital that they need. So Sonia asks, is it wise to have a silent owner? And what precautions should I take for my businesses if you're going to take on a silent owner or a silent partner, as they say?
So, is it wise or not? If you need the funding, sometimes it's very wise. The question is, what are you getting in return, or what is the owner or silent partner getting in return? So, the precautions you need to take is make sure that there's an understanding of what the silent partner is getting and what you're getting. The best way to do that is creating either a shareholder agreement or an operating agreement. It's essentially a contract between the partners that'll spell out exactly what needs to be done, exactly what the silent owner's duties are, and exactly what the other partner's duties are. So the most important thing is put it in writing. I get a lot of people that come to me that are friends, best friends, and they're starting a new business, and they say, well, we're best friends, we trust each other, and so on. So they don't do any kind of agreements between them, and then issues arise later on where one of the friends stops working, but they're still receiving funds. And then they come back to you and say, well, XYZ, and we don't know what to do. That's why you, in the beginning, just create an agreement between the parties, an operating agreement, shareholder agreement, and spell out exactly what needs to be done. That way you avoid any kind of issues later on.
Yeah, and that's a good point. And I know you've seen this in the past. Like, what do you do when there's no agreement and they're 50-50 partners and they both want to do opposite things? How is that solved?
So the problem is, 50-50 partners, whether it's a corporation or an LLC, there's two things you can do. One, just deal with whatever it is, and hopefully it passes, which it generally doesn't. The next thing you do is close the company. Well, if one partner doesn't want to close the company and the other one does, the only thing that's left is litigation. So the statute provides that the company can either be closed voluntarily or involuntarily. And when there's 50-50 partners, if there is a deadlock between them on any issues that are material to the company, the next step is a dissolution, voluntary dissolution that's going to be handled by the courts. There's going to be receivers appointed. So the company, another reason to have an operating agreement or a shareholder agreement is to avoid issues like that.
For sure, because I'm sure the receiver is not free, right? The attorneys are not free. So once again, and you're talking about dissolving an asset that you built together. So once again, the partners are losing, and everybody else in the system is making money off of the hard work that was put in by at least one of the partners, if not both of them. So so let's move on a little bit to I know it's a really hot topic right now. The Small Business Administration, or the SBA, and the PPP loans, or the EIDL loans. Can you give us a little background on what's going on with those?
I believe we're now in the second round of PPP loans. The first round was last year. A lot of people did it at that point. There's another opportunity now to get a PPP loan. If your business was affected from year to year, 2019, 2020, I believe it's on a quarterly basis, you're entitled to get a loan. There is a 2-week period for small businesses under 20 employees to apply currently. I want to say that the 2-week period is over by the end of today. So if you're a small business, self-employed, one employee, and you're thinking about doing a PPP loan, definitely recommend doing that by the end of today, at least starting the application, because you will get priority at this point. And it opens back up, I believe, tomorrow to everyone else and through the end of the month.
Absolutely, and this is for nonprofits as well, and it's really important that you get your applications in as soon as possible. If you have a banking relationship, if you have a checking account with a bank right now, reach out to them first. If not, I know PayPal's doing it. Your payroll company might be able to help you out, whether it's ADP, Gusto, or anything like that. I believe you're correct. Today is the last day for the priority for the small businesses, and then through the end of the month, March 31st, the second round closes by March 31st. So those loans are 100% forgivable if you use a certain amount for payroll expenses. I believe it's 60%, which, I mean, this could save your business. So make sure that you're checking out. Go to SBA.gov to check those out. If you do get the money in, Paul, what do you think the best use of those funds? Obviously, some of the funds need to be used for certain things for it to be forgivable, but what would you prioritize those funds in if you were representing a business that was struggling?
Sure. The first thing I would recommend is probably putting it in a separate account. That way you can track exactly where the money's coming from. If you commingle it with your regular checking accounts, it's going to be pretty hard to to track it. Use it for your business expenses. Use it for your employees. The main thing, as you said, as long as it's used 60% for your employees and rent and your leases, it'll be forgivable. So make sure you're using it for business expenses. Don't use it for obviously your personal expenses. That's where trouble comes in. There's been a ton of cases where people got the money and then used it to buy Ferraris, Lamborghinis, and now they're being investigated and prosecuted federally. So just make sure that the main thing, use it for business expenses and you won't have an issue. Now, if the business expenses of debt, just understand that if you're paying all these debts, that there's a potential that this loan becomes an actual loan as opposed to a forgivable loan. That needs to be repaid.
Yep, and so that's all great advice. I completely agree with it. So 20 minutes have already passed. This is flying by. So I want to get to an important topic as well. I get many people that come in, they're in litigation with their business. Their business doesn't have any assets because generally speaking, they are the business. They're operating a service. They're the only employee or they have one other employee. They can't afford the litigation cost. So they just want to walk away from the business. And can somebody, and this is the question, can somebody just walk away? And Jonathan asked, how do you properly close the company if there's really no assets in it? Can you just walk away from the litigation and be done?
Well, and that's also a question for you as far as the bankruptcy part of it. But I'll address it before that. If you're not planning to file bankruptcy, can you just walk away? Well, you can walk away. There is a potential that the business that's not wound down properly, you can get what's called piercing corporate veil, where instead of the business incurring a debt, now that the company or whoever's suing you, the vendor, can potentially go after you. So in that sense, making sure that you properly wind down is the most important part. If you have creditors, if you have assets, any assets, clients, client list that could be of any value, those need to be properly, I guess, sold. Now, if your asset is just your head, your mind, that's a different thing. Obviously, you can't sell that. But
well, not in this country, but other countries maybe.
Yeah, very true.
Yeah, so I completely agree with you that you got to be careful, especially if there's UCC1s, which are security in any and all of the assets. You can't just walk away from this company, take your accounts receivable, your clients list, everything, and start company B, which is essentially company A without the debt. Some ways that you can deal with that debt would be if the company still has revenues, you can look at a Chapter 11 to reorganize the debt, lower what you owe, and then work out a payment plan. If the company does have assets, soft assets or hard assets that can be sold, you can look at an assignment for the benefit of creditors, which is under Florida statute. It's a Florida bankruptcy, basically. And you can do a Chapter 7. Some judges say Chapter 7 is per se malpractice. So you got to be very careful when doing a Chapter 7 for a business. It makes more sense to do an ABC, Chapter 11, or like you said, properly wind down, send notices out to all the creditors. Make sure it's a very open process where they see that you're not concealing assets so that they can't pierce the corporate veil, go after the new company, go after you individually. So I think that's all very good information. We have a couple of questions to wrap this up. We're already at about 25 minutes in, so let's go through them. Susan, is there a difference between a corporation and a limited liability company in Florida?
So those are two different types of entities. I get a lot of questions. Well, should I open up an LLC or should I open up an Escort? Those are two different things. A corporation is owned by shareholders. A limited liability company is owned by its members. The general gist of a limited liability company is you got to see it as basically a partnership as opposed to a corporation. In fact, if you refer to a limited liability company as a corporation, it's It's not. It's a partnership. A corporation, again, is owned by shareholders. It's a little more. There's a little more involved in owning a corporation as opposed to an LLC. There are more guidelines as far as corporations. There are more requirements as far as corporations. LLCs make it a little easier as far as what needs to be done. And I previously mentioned the Escort. That question is asked all the time. An Escort is just a tax election. It's how a company is taxed. So an LLC, when it's first opened, is a partnership. You do have the option to elect S corporation status, where a lot of people do that. And a corporation, again, you have two options, either a C Corp or an S Corp. If you're a small business, you're going to be an S Corp where you get a pass through. Now, the other things to look at is ownership. Who can own an LLC and who can own an S Corp corporation? Generally, an S Corp corporation can only be owned by citizens or residents of the United States. An LLC can be owned by foreigners or anybody else, or another corporation, a trust, etc. So there are a lot of differences. That's why it's always recommended to talk to an attorney, just to make sure that you're setting up the proper company for what you need to. Yep.
Awesome. Well, thank you, Paul. This has been fantastic. If anybody's looking to set up a business that's listening, how could they get in contact with you?
Yeah, they can call my office, set up an appointment. My phone number is 954-281-8888. Or they can send me an email personally. My email is paul@kogan.law. And feel free to contact me. We'll set up an appointment, and we'll go from there.
Awesome. Well, thank you for spending the time. Thank you for the valuable information, and hopefully we'll have you on again soon.
My pleasure. Looking forward to it.
All right. So that was fantastic. That's very helpful information from Paul Kogan. We really appreciate you being part of the Debt Life podcast. I hope this is helpful information. If you need any information from me, you can certainly go to our website, vanhornlawgroup.com. You can also give me a call at 954-637-0000. As you know, we do consultations that are free on nights, weekends, whatever's available for you. We are available. Also, I have two books out there: The Debt Life, Bankruptcy in Florida. If you go to our website, you can check those out. Thanks again for joining me in this episode of The Debt Life. As I said, I hope the topics are helpful. We try to give as much free information as we can to help you guys out. As always, I wish you the best and look forward to seeing you in a couple weeks at the Debt Life podcast. Thanks, guys.